Thank you, our viewers, for joining us. I'm Karaga Baldwins, and we're delighted that you're joining us this late evening on a Friday night after the news broadcast. For purposes of making sure that we continue building our business environment and, of course, the economy, we've decided today to pick on a very quintessential subject, and that is the issue of intellectual property rights, which includes trademarks, patents, of course, copyrights, and industrial design. For purposes of just building a background on this discussion, let's have this preface, then I'll come back to the studio discussion. Thank you.
According to the World Intellectual Property Organization, WIPO, intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. Intellectual property is protected in law by, for example, patents, copyrights and trademarks, which enable people to earn recognition or financial benefit from what they invent or create. The copyright concept came about with the invention of the printing press and with wider literacy. In 1961, the United International Bureaus for the Protection of Intellectual Property signed the Rome Convention for the protection of performers, producers of phonograms and broadcasting organizations. In 1996, this organization was succeeded by the founding of the World Intellectual Property Organization, which launched the 1996 WIPO Performances and Phonograms Treaty and the 2002 WIPO Copyright Treaty, which enacted greater restrictions on the use of technology to copy works in the nations that ratified it. Uganda's copyright laws are standardized somewhat through these international conventions, such as the Berne Convention and Universal Copyright Convention. On the other hand, a trademark is a recognizable sign, design, or expression which identifies products or services of a particular source from those of others, although trademarks used to identify services are usually called service marks. As for a patent, it is an exclusive right granted by the government for an invention which is either a product or process that provides, in general, a new way of doing something or offers a new technical solution to a problem. Tonight, we seek to understand how Ugandan inventors, innovators, industrialists, artists, entrepreneurs and businesses should obtain the necessary support towards the protection and enjoyment of their intellectual property rights.
Thank you, our viewers, for keeping with us. Once again, I'm Karaga Baldwins, and thanks for always keeping us as your #1 station. So the important question is about our intellectual property rights. And in studio, I have a resplendent panel of two gentlemen from Ursb, and to my extreme left, I have James Tony Lubwama, the Senior Patent Examiner at Ursb. James, you're welcome.
Nice meeting you.
And in the middle here, I have Gilbert Agaba, the Manager Intellectual Property, Ursb. So let me start with you, Gilbert, yes, about the legal framework of this particular aspect of intellectual property. Yeah. We need just to give us a summation of the provisions, because there are quite a litany of them. The 2004 Uganda Registration Services Bureau Act, the Trademarks Act 2010, the Copyright and Neighboring Rights Act, and then the Industrial Property Act 2014. So just a summary of how these come together and how they support the endeavor to ensure that intellectual property rights are protected and enforced.
Well, thanks for having us. Intellectual property is administered by Ursb. Uganda Registration Services Bureau is the National Intellectual Property Office. It was established under the Ursb Act, and it administers the laws that you've just highlighted. These laws provide for protection of creative works and innovative ingenuity as Ugandans. They are actually up-to-date laws. They amended old laws from the colonial era, following after the requirements of the organization called World Trade Organization, which set standards for protection of intellectual property. So at Ursb, we administer these laws. That's not the only thing we do, obviously. As you're aware, we also deal with the registration of businesses, registration of marriages, and also we are the official receiver. But from the perspective of intellectual property laws, if you want to do anything except for plant variety protection, you'll have to come to Uganda Registration Services Bureau. The agency is headed by the Registrar General, and all of us are there to support the public by ensuring that their IP is protected. if you are a business person, one thing that you have to bear in mind in part of your business plan is to plan on how you are going to manage or how you are going to benefit from that, the ideas you've created. And the systems are there, the platforms are there, the laws are there to help you achieve that objective. Maybe as we go on, I'll share on how you can do that.
Aren't there too many laws, just as they've been stated out? Because I managed to extract just out 4 of them.
Yes.
And don't these complicate actually the enforceability of this?
No, there are not too many laws because there are different types of intellectual property. Like you heard from the clip that just played, there's trademarks, and they are protected under the Trademarks Act. These protect distinctive signs and marks that we use to distinguish our products in the market. There's the Industrial Property Act, which protects inventions using the patent system as well as utility model system, and also provides for protection of designs that define how products look like. Then there is also the Copyright and Neighboring Rights Act. It protects copyright in respect of literary and artistic works. So we're talking about things like movies, films, books, sculptures, photographs, databases, computer programs. All that is protected under copyright. Obviously, there are other laws. There's geographic indications, which will soon come into force, and we'll start implementing that. There's also the Trade Secrets Protection Act that provides for protection of undisclosed confidential information that gives you a competitive edge as an enterprise. So there are not many. They are adequate for the purpose, and we as Ursb, we try to refine them every now and then to make them practicable and also effective for the users.
Oh, brilliant. And now, James, to you, because help us understand the relevance of this to, of course, economic and business development, to an environment of ours as we are trying to build the necessity of these intellectual property aspects. How relevant and contributive are they to economic, business, and, of course, national development?
Thank you, Baldwin. Like Gilbert has indicated, the mere fact that we have these laws in place, it means we have a system in place that can help to protect our creators, our innovators in different fields. If somebody has a design, they have where to run to be able to protect this design. Probably Gilbert noted the Industrial Property Act. It came into force last year. And before that, before we had the fees, before we had the regulations, people were coming into office. I have this package, I want it protected. I have a shoeless, a shoe sole design, I want it protected. And like he indicated, that they are all forms of IPs, but they have their unique ways. So you can't just bundle them into one. So you try to force one into another system, but you really see that it doesn't fit. So having these laws in place gives us a system to be able to protect all our innovators in the country, who have these different kinds of innovations. But the benefits one, the system gives you ownership. Who came up with what? I have this design, but who designed what? Who composed which song? Who wrote which book? So we have a system that can give us that, can clearly define that for us because of the existence of these laws. But to me, for example, if you look at trademarks, I don't look at it as just a sign. Just behind the sign NTV, you could have over 50 people. So to me, each sign that I see, each trademark that I see on the register, I imagine behind this, I just pray there are 100 people behind this. So you don't just say we have 3 trademarks. Behind that, there are hundreds of people behind this, just because one individual or one entity owns this trademark. And that is just for trademarks. But just to extend it a little, if I look behind like 10 years back, you never used to see a lot of local juice. But if you went to even the upscale supermarkets in this country, you will be able to find local banana juice. And it's banana juice, and I'm sure almost all of us, we know how to make banana juice. But I will go to a supermarket and pick on one. You'll find that behind that small trademark that is lying on a shelf, there are 10 or so people. So to me, that is something that I want. I'm able to find Bushera almost in all supermarkets, upscale or not. So to me, because of this system, there are many benefits, and that is just on ownership. That's just on ownership. But there is also possibility of licensing. You know, if somebody, you are doing business, but probably things don't, but the trademark remains on the register. We've had cases where people come to our office and, I no longer see products out of this, the products using this trademark. Is there a possibility that I could acquire? When you say you want to acquire somebody else's trademark, that means they have to either sell it to you or issue you with a license. To me, I believe the system is working. And
so implying that an intellectual property is also somehow a tradable property.
It's tradable. It's tradable property. You can license it. It's property.
Yeah. So we'll come back to that. Just Gilbert, help us. Okay. So just to summarize here, to make sure that contextually, Ursb owns this issue of intellectual property. So what does a person have to do to come and have their patent, their copyright, their industrial design, or this particular intellectual properties that you registered, to make sure that they gain or get that ownership and it's protected?
Okay. Like I said, as part of an enterprise's business plan, one thing you need to consider is if I'm developing a new product, how can I protect myself? And if I'm entering a business area and I'm selling all sorts of articles, I have branded these, I'm going to develop goodwill, I'm going to develop a reputation concerning that product. How do I protect myself? You come to office, the first thing you should do is come to Ursb and do a search. Figure out if I come up with a name called Baldwin for my water, is there someone else who uses the same name? Before I put it out, and then I find I cannot use it or I'm stopped from using that name. So you do a simple search. It's better that you also consult a lawyer. So I may advise you on maybe the legal requirements that are there, but it is a process that you can also engage in yourself. The other thing you need to consider is what type of IP do I have? You heard there is patents, utility models, trademarks, which one applies to you? But you find that on any given product, you have different IPs that apply. If you have water, maybe the juice, the formulation for the juice.
So that's what you do, just the copyrights, trademarks, patents, and utility
those are
models
things
and
where
design.
yes. So if you have juice, the formulation for the juice, you can protect it using a patent system. The cup or the shape of the bottle, you can protect it using a design system. Then the branding of the juice, you use a trademark. So you identify the types of IP that you have and then come to our office. The registration process is a requirement for you to get protected. If you do not register, you will not be protected.
Yeah, and I'm going to come specifically to the costing and the approach of how you come and do the application and what it implies. But let me first go for a break, then we break that down. Thank you, our viewers, for keeping with us. We're discussing intellectual property, and let's have a break and then come back and indulge more in this particular phenomenon. Thank you, our viewers, for keeping with us. We are discussing a phenomenon that is of such cardinal importance in the effectiveness of how to run an economy and business itself. And we're talking about intellectual property rights. That is copyrights, that is trademarks, patents, and industrial designs. And gentlemen, so just to make sure that people fully understand how we get to engage into this, I need you to help us in these particular 4 block areas of the intellectual property. How does somebody apply specifically? What is the cost to Ursb? So let me start with you, James, to guide me on patents and the issue of industrial designs. How does somebody get a patent registered or industrial design registered or perhaps acquired from Ursb, and what is the cost?
Okay, thank you, Baldwin. So to get a patent, first of all, like it was indicated in the intro, a patent has to be like a solution or a product to a process. It's a process or a product which is a solution, a technical solution to a problem. So for anything to qualify for patent protection, there should be an element of a solution to a problem. So, for example, if somebody comes up with, for example, a simplified something which, for example, it could be a pharmaceutical product which is trying to address a problem which could be a disease. So if it's a product or a process that is new, it has to be new as one of the qualities. It has to be inventive. Somebody should have thought to address this problem. So you really see that there is some knowledge added to address that problem. And of course it should have use. So it has to meet those three requirements. It has to be novel, it has to be inventive, and it needs to have utility. So the moment it meets that, we go through the process of having an application. There is a problem, you've provided a solution. So we need to go through the process of coming up with the application. And that, like Gilbert indicated, that's when you really need to engage the technical person and the legal to be able to come up with this application. Now, the moment those two minds come together to come up with an application, we can now proceed to fill the application form. The application form where you put your title, but our titles are normally technical titles because there is normally a confusion where people want to use trademarks to appear in their patent, in the titles for patents. But the title in this case should be technical. It should give an indication of what this invention of yours is actually about. So it should have a title, then you put the details of the inventor. If the applicant is not an individual, you also put the details of the individual. You fill that application form, and then we go through our formalities. Of course, before you submit, you also need to pay the relevant fees, like we are going to indicate. So with the application, with your form, filled application form, and the proof of payment, it comes to the stage of formalities. Did they include this? Is the title technical, like I've indicated? They've not included the trademark. Does it have all the components of what a patent application should have? So those are the things that we do at formalities. If it goes beyond that stage, then we proceed to substantive examination to check if it meets the three requirements of novelty, of inventiveness, and utility. So that is when we come in as patent examiners. So we have very many databases in different languages, because at the end of the day, the patent system is universal. In as much as protection is territorial, you apply through the Ugandan system, you get protection in Uganda, but the search is almost universal. So you have to look at all these documents, whether in Japanese, whether in Chinese. So we have those databases and we have those translation tools that have that capacity to actually confirm that if you put in, that's why the titles have to be technical. So when you throw it in, then it can give you, other documents or related documents from other jurisdictions. Yes. So we go through that process to confirm that it's novel, it's inventive, and it has utility. So the moment we do that, the moment we confirm that it's positive, if it meets the three requirements, then you go ahead to issue the certificate.
Okay, and the payments is about the search is 25,000 as you like the list of the payments. Just as they are
no, for patents it's different. It was indicated somewhere, but they are different. You have 100,000 for application. You apply, and then at the stage of examination you pay 150,000, and then you pay 90 for the certificate. Yeah,
the other previous listed bit was about trademarks.
Was for trademarks. Yes.
Okay, so let me actually come to Gilbert. Thank you. That is pretty elaborate enough. Trademarks and copyrights. What is the procedure?
The procedure is rather straightforward. I think it's one of the simplest procedures. You just fill out a form indicating the logo, brand name, whatever you're using. On that application form, you tell us you're the owner of the mark, you sign it, you pay a search fee, which is 25,000. If you are not from Uganda, you pay a search fee of $60. But if you're Ugandan, it's just 25,000. Then there's an application fee of 50,000. You pay it in the bank, you bring your application. We will go through our internal process of looking at your application to see whether your mark qualifies for registration. When it does, we give you a notice. You take it to Uganda Printing and Publishing Corporation and publish it in the Gazette for 60 days. So from the date you put it there, you count 60 days. After 60 days, if Baldwin or some other person doesn't show up and say, no, this I have more rights to this mark than you, then you pay 100,000 and you get your certificate, and you start owning that property from the time you filed. You get an asset just like that. You can
But if you're talking about this being a universal, a worldwide, perhaps property, abstract property in that essence, if somebody in China or perhaps someone in Thailand who has a claim to that perhaps is not able to come in here, and then at a later time when you have issued that trademark or copyright, and they come and find that there was a duplication about this or an infringement of that copyright, what would happen? Or don't you find yourselves at times getting in such mistakes?
It's not a mistake per se. If you had my colleague, he said intellectual property protection is territorial.
Yes.
That simply means...
But it's universally applicable.
Yes. So you are protected in the country where you seek and obtain registration. So if you have the mark Baldwin for water in Uganda and you register it in Uganda, someone else can use the same mark in Kenya or Rwanda without infringing on your rights because you're only registered in Uganda. So as a business person, you have to think of where you're going to sell your products or where the infringement is going to come from. Then you have to go and register in those countries as well.
Or for every economic territorial precinct that you're going to operate in, you have to register.
Yes, you have to register.
Okay, that's a new discovery. So, James, we need, according to Article 27.1 of the WTO agreement on trade, of course, the TRIPS, the trade-related aspects of intellectual property, and Section 8 of that same Act provides that in order for an invention to be eligible for patent protection, the applicant must ensure that the invention falls within the scope of patentable subject matter. In Section 46 of the 2006 Uganda Copyrights and Neighboring Act provides, which you're very familiar with for infringement of copyright or neighboring rights as follows. Infringement is deemed to occur where without a valid transfer, license, assignment, or other authorization under the Act, any person deals with the work of performance contrary to the permitted free use, and in particular where that person does or causes or permits another person to do the acts as many that you usually list. So I need to understand, because the nebulous area of concern here is the international territoriality and the implications of you having a contestation with someone else perhaps who comes from another country and comes with it. So we need to understand if these laws are evaded or infringed, what happens by the local participants, and perhaps when someone from outside comes and makes a distortion, especially out of piracy and counterfeiting?
Thank you, Baldwin. So you've talked about the issue of the requirements for patentability as outlined in the law that you've stated. But what I would say is that there is the issue of harmonization. So you'll find that what is provided for in the international instruments, by way of domestication, we end up accommodating for those provisions. So it's not like they are just there in the international. So when you are party to that, then there is a way you have to domesticate, to kind of own up, to ensure that you do what the international instruments are required of you. So if I'm to speak from the perspective of patents, because like I indicated, that the different forms of IPs are unique in nature when it comes to application. In as much as they're all IPs, the way they are applied, you kind of tweak these things to suit the respective form of IP. Like it was indicated there that it has to be patentable. And for something to be patentable, it has to be novel, it has to be inventive, it has to be industrially applicable. And that is already clearly stated. You don't even have to refer to the international instrument. It's clearly provided for in our local law, national law. Then when it comes to the issue of whether, something you could be doing something and it's already probably being done.
Yes,
I think that is something
absolutely.
That
it's not registered with you people.
It's not,
and
yes.
And somebody is flourishing out there. It's not something registered, but it is an identity.
I don't know whether we shall have all the time to exhaust all
no, just about not necessarily.
Because the number, for example, there is the issue of well-known marks when it comes to trademarks. Something may not be on the register, you get it, but it's well known, it's well known. So there are some international instruments which also require us to ensure that such marks are protected. That's one. And we are party to those instruments. For example, you might wake up and say, you know what, I want to put, for example, the Kenyan coat of arms on the register. There are other provisions, there are other instruments also which protect such, such emblems. So, and we are, the moment you are party, you are under obligation to ensure that such, such trademarks, such emblems are protected, even protected even in your jurisdiction. Then when I go back to patents, for example, I talked about the issue of search. When somebody comes to Uganda and probably wants to apply for something as a patent, and then I carry out my search, and I find that probably somebody in China already has done this, I can advise my national applicant that, you know what, this is not a completely new technology. But because it's not on the Ugandan register, to bring in the principle of territoriality, like Gilbert indicated, I may not give them a patent, because patents are given to completely new inventions, inventions. So if it's not, and it's already existing elsewhere, but not on our register, I have another layer of protection I can offer my Ugandan. I may not give them a patent, I'll offer them a utility model. Say, this is not on our register, you can go on the local register, but I will not give you a patent, because patent, it means you've added knowledge, you've added something to the body of knowledge. But if somebody is just making a modification of what is already existing, I don't give them a patent, because somebody elsewhere already owns that, but I can give them another tier, another layer.
Okay, just lastly, within a minute, if somebody is found to have trade, he is in a trade business.
Yes.
However, and they have these articles or emblems of business projection and image branding out there, but they're not registered with Ursb.
Yes.
What happens? Just in a minute.
The law provides for that, because it's not criminal that you use a trademark which is not on the register. It's not criminal that you don't. But if it so happens that you are using probably a trademark that could be infringing what is on the register, somebody may have to reach out to you and say, please, kindly, this register, as in I own this trademark, kindly cease using this trademark. Otherwise, if somebody is using a trademark and out there, it's not on the register, and he's not infringing on anybody's right, it's not criminal.
Okay, thank you for that clarification. Gilbert, so let's talk about the body that governs, of course, all intellectual property authorities, which is WIPO, and the World Intellectual Property Organization, headquartered in Switzerland, and just having about 191 members. So Uganda is a member of WIPO, we need to understand, and in 2013, of course, we had a case of Coca-Cola against Reham. Quite a combustible engagement, and even still prevalent. People still wonder how Reham does its business, and I can see James really smiling. So what are the modalities in our national arrangement, especially spearheaded by Ursb, to ensure that we are regionally, internationally compliant with these particular intellectual property principles? And what is your relationship with WIPO itself and, of course, the East African region, just to make sure that we are consonant with the international norms, besides just getting the articles? Because this case was phenomenally combustible, Reham and Coca-Cola, and it's still pretty perturbing that it is continuing. You see, okay, I think I shouldn't go along that line.
The technicalities,
yes,
we are here for that.
Yes, thank you. Well, you raised two things. I will start with the last one on the issue between Coca-Cola and Harris International. Trademarks, obviously, there's going to be always a dispute when property is involved, with people claiming adverse rights. What happens is that when you feel or you deem that someone else is using without the authorization your intellectual property, or otherwise is copying your intellectual property, you can you have remedies under the law. There are civil remedies, there are criminal remedies, but I'll come to the criminal remedies later. First, for the civil remedies, you have options. You can sue this person and go to court, or you can choose to mediate or go to arbitration. So arbitration and mediation are the best options, because in those using those means you can maintain the business relationship. Instead of this person being an infringer or someone who's trying to steal your IP or misappropriate your IP, they can become your business partner. You allow them to stay on the market, provided you agree on how the IP is going to be used in the market. And it's a good method. If you go to court today, they will advise you that first consider mediation and arbitration before you choose for the litigation, because litigation takes time, takes money, and you always have one winner. Yet mediation, you can have a winner,
win-win
situation for both of you. So it possibly is what happened with Harris and Coca-Cola, that the parties sat and settled their matter, and we encourage this, that this is the best way to resolve disputes when it comes to IP. Obviously, there is the other side of where someone is counterfeiting or is a pirate. Now, counterfeiting is when I start using a resembling mark to the one registered. Piracy, obviously, is reproducing copies of copyright protected works, like copies of books, of movies, that kind of thing. So IP crime is a rather big problem, a very big problem, and people are not aware in most instances that they are committing crimes when they are engaged in these kinds of practices. But when that happens, if you are the owner of the IP, and you can complain, you write to Ursb, you put your complaint to us that so and so is counterfeiting my trademark, or he is a pirate and is misappropriating my copyright. In that case, if you choose to go the criminal side of things, you need to own or show proof that you own the IP in the first place. By the way, you cannot claim that your intellectual property, specifically trademarks, that they are being infringed when you have not registered. So the function of registration is protection. No registration, no protection. So you need to provide proof that you own the IP. Then the office can intervene. Ursb has set up an intellectual property enforcement unit manned by policemen who are well trained, and their job is to deal with IP crimes. They are scourge, we know it. They result in substandard products flooding our market. They facilitate shadow businesses and organized crime. These people who are involved in counterfeiting are the same people who don't pay taxes. And obviously they undermine genuine businesses. So they are a problem. And it's an economic issue that we are taking seriously.
Yeah, true. And that's quite where the mix of the whole of the whole contestation about your ability to enforce is that, you have that enforcement arm, but it seems the problem is rampant, that duplication of things is really excessive, piracy is huge, plagiarism is out of the roof, and James, I'll come back to just after the break to give me just maybe evidence of the cases that you've dealt with, essentially to show that actually you can be able to enforce this particular phenomenon. Thank you, viewers, for keeping with us. And when I come back, we'll be wrapping up this discussion. Perhaps I'll make a citation of some of your online comments just to see how you're relating with the discussion. Thank you. Thank you, our viewers, for keeping with us. We are wrapping up this discussion about intellectual property rights, which is extremely essential in making sure that you have a very coherent economic and business environment, and for people to be able to create and depend on that creation for their own aggrandizement and improvement of lives. So, James,
Yes,
we are talking about somebody taking a case, okay, they have infringed on my personal intellectual property, and I need a remedy now. Just help me understand the procedure, because I need to know what the cost is, what the actual procedural dynamics are, just as he was explaining, the different issues of, making sure that there's arbitration, there is a criminal. But now, what is the actual procedure? I have phoned somebody, taking on my property that without, of course, consent. So how do I resolve that? Procedurally, and the cost implied.
Of course, there are two ways. If somebody is trying to register something, you have a trademark, for example, and somebody is trying to register something which you think is confusingly similar to what you already have. So before they register, in that case, we, as the institution, we provide for opposition. We provide, and it's provided for under the law. So you say, no, there is, I've seen somebody is trying to register Baldwin, something which is close to Baldwin water, which is my trademark on the register. So before the moment they gazette, like he indicated, we gazette for 60 days under the law. So before expiration of those 60 days, you come to our office. You pay, is it like 20,000 for opposition?
No, it's 100,000.
It's 100,000 for opposition fees. That is for trademarks. Then we go through. Of course, you serve the other party, and then the process of hearing the case.
So the precondition of contestation is that I should be registered with the authority.
You should be registered.
Okay, I cannot come and make a claim about this particular property when I actually have no registration with you.
You don't have proof of ownership, because now it becomes complex. It becomes complex. That is probably if somebody is attempting to register, and they've not yet gotten a register. They've not yet gotten a registration certificate. But if somebody is trying to...
So those are the criminal offences and the punitive measures that are taken, just
yes.
as a highlight.
But if somebody is already on the register, in that case, you have to go to court, because we gave you the 60 days within which to oppose this individual. Now, should you realize out there that, somebody could be infringing on my right, and this thing is already on the register, then in that case, we can only remove it from the register if you bring a court order instructing us to remove that trademark from the register. And you have to go to court. So the fees that you have to pay them to the court. I don't know if Gilbert, because this is his area.
Yes, any comment on that? Besides, of course, the issue which I was raising before the break about the environment itself. So I need you to make maybe a supplementation on that, but also give us the evidences that are out there of the cases that have been conducted, besides the one of Riham, or rather of Harris and Coca-Cola. For normal business engagements, do you have on record that which has been done so far? And perhaps I don't know what you were saying.
Yes, obviously there's a record of the cases that we have handled. I mentioned that we have set up an intellectual property enforcement unit. This unit began operations around May last year, so they've barely really been up and running. And they've so far handled about 43 complaints in dealing with books, pirated books, dealing with toilet paper, juices, broadcast piracy, all those issues, they have dealt with them. But the important thing is that if you have a problem, at least what we've done is set up a remedy or a facilitation for you to achieve the remedy for people who are pirating your works or otherwise counterfeiting your good products. Importantly, again, is that you must register your intellectual property. You are not going to come and complain that I see so-and-so, so Baldwin water, then some guy comes up with bold wine water. So you're not going to come and say, oh, this guy is appropriating my intellectual property. In law, there's no infringement because you have not registered. That's why it is important that you register your IP. whether be it a trademark. And for copyright, there is no requirement for protection. Is automatic. The moment you create the work, the moment you write that book, you create that film, you sing that song, you are automatically protected. But you need to register with our office that we may have a record that you are the owner of the work, and when it comes to enforcement, we'll have a basis for intervening. So the procedure is there, and it's free. We don't charge a fee for enforcement. We have a unit to facilitate you to enforce when you choose to go via the criminal procedure. But if you choose to go via the civil procedure, like I mentioned, maybe for emphasis, there are three options basically. You have mediation, where you negotiate with the person who is allegedly stealing your IP, and arbitration, where you get a third party to come and help resolve your dispute, or you can go to court and tell court that, you know what, we want you to resolve our problem. But as a business person, you have to look at this wholesomely. How much will it cost me to go to court, other than me sitting with this gentleman or lady and saying, let's agree and see how we can. You can use my mark with my authorization. You can pay me maybe for the little losses I've made, and allow you to stay in the market on these and those conditions. So that's why mediation is important. Possibly that's why you see Harris as well as Coca-Cola on the market, because they manage to settle their matters without necessarily allowing the court to come down with a decision, which is usually a one-sided decision. There is always a winner, there's always a loser. But that's not what you want. You're talking about commercial enterprise. You're talking about business. You're interested in succeeding in your business. So if as many people can use your IP to generate income for you, the better than spending that money on court proceedings. So you can choose these three options for civil remedy. And as you saw on the screen there are various remedies. If you do not come to a negotiable settlement, court will make decisions. They will give certain orders. They will order you, if you are an infringer, to pay damages. They will order you to account for profits you made while you are misappropriating or misusing this other person's intellectual property. They will give an injunction. So they will say you are not going to import these batteries in the country, and you have shipped maybe 10 containers of your batteries. They are stuck somewhere. They cannot get into the country because someone has an injunction, and you are going to get out of business, obviously. So there are these orders that court can issue against the person who is, in this case, who is the infringer. But the remedies are there in the law. We have to test them and see how they work out for us.
Okay, thank you, Gilbert, about that. We hope that it's workable, because it seems it's a very sophisticated area for somebody to take on. That's procedural action.
I think it's a bit sophisticated, but
because of the cost and the time. James, so let's wrap up with this. Give us just an update on how far you've gone as Ursb. Do you have the numbers of the trademarks, of the patents, the corporates, the intellectual property registrations that you've done? And what's the future forward? Do you see that this area is going to be supported hugely by the business and economic community of country, or people just do not feel that this is pretty important?
Thank you. We realize that the numbers are growing, but I clearly indicate that there is always room for improvement. So, for example, we are carrying out a lot of sensitization. We realize that many people may not be on the register just because they are not aware. And each time we have a sensitization campaign, we see many people coming to our office to register. So the issue could be that probably people may not be aware. So that's one of the issues that we consider, and that's why we carry out a lot of sensitization to ensure that we communicate what the benefits of the system to interest people to be able to register. I was checking the register before we came in, and we have over 60,000 trademarks. So just imagine a situation if probably we have like 10 people behind each one of those trademarks. It would mean good business. It would mean
local and foreign.
Local and foreign on the register. So the fact that probably some people are still out there and they are not on the register, it's not that they don't want the system or they are just apprehensive about the system. No, some people are just not aware. You go to these people after community, we are not aware that such a system actually exists to protect such things. So through awareness, through simplification of our business processes, simplification to make this process as simple
as
for
possible.
people. Through awareness, of course, simplification, automation. Very soon you'll be able to make simple searches on our register. So we are doing all that to ensure that we bring the system closer to you people. You are able to make a simple search. If you are out there, you are at your place, and you are trying to think of a trademark, you can be able to conduct a simple search, and you know if whatever you want to submit has chances of going through. So all these are things we are trying to do to ensure that people embrace the system.
Okay, thank you. So, Gilbert, last 30 seconds, the location of Ursb, or how people can now get in touch with Ursb, and any kind of contact point that they need. Just 30 seconds.
Yes, we are situated at Plot 5, Georgian House. That's George Street. That's the street above CPS. Everyone knows CPS. So that's the street above it. That's where you find our head office. But we have offices in the region. We have in Arua. If you're in Arua, you don't need to come to Kampala. We have offices in Gulu. We have offices in Mbale, Mbarara. And we also have branches in Chikubo. We have branches, a branch at Posta, and also at Ghana Investment Authority. You can also find us online on our website at ursb.go.ug, and we also have social media presence at URSB HQ, all caps, and you can post your questions there. You can ask for service or how to access our services, and also interact with us to see, to let us know of your needs, to find a way to better serve you.
Okay, thank you. And on that point, Gilbert Agaba, Manager, Intellectual Property, Ursb, and James Tony Lubwama, Senior Patent Examiner. It was a great pleasure indeed having you here on set.
Thank you.
We wish you the best in your business, and that Uganda's business environment grows and develops in such a phenomenal way that will be very competitive. Thanks our viewers for keeping with us on this Friday evening, and the discussion has been about intellectual property. So if you have a patent out, rather maybe anything of creation out there, you've written anything, you have a song, you have a design, come to Ursb and have it registered so that you can have a competitive and an economic value out of it. I'm Karaga Baldwins, and we thank you always for keeping us as your #1 station here at NTV. Please come talk to us about such discussions if you're a company out there, or a ministry, or an agency of the ministry, or an NGO, and let's have a discussion that is fertile with great ideas and what is being done. God bless. Keep logged on to the NTV.